Hi friends, this is Prem. Today we are going to discuss a very important topic. What is EB2 NIW and how will it help you in your green card journey? The typical I-140 process for a green card can take more than a year and a half, sometimes almost 2 years. However, when you file an I-140 using the EB2 NIW option, it could take us little as 45 to 90 days only. What is the procedure for processing an EB2 NIW?
We are going to discuss all the questions with our Manifest Law attorney Henry, and Manifest Law is giving a free consultation to everyone. Just scan the QR code on your screen and just schedule your free appointment. You can ask any visa related queries or any immigration related queries to them. It's completely free. Hi Henry, welcome to the show and thanks for your time.
Hi, how are you?
Yeah, good. நீங்க எப்படி இருக்கீங்க?
நல்லா இருக்கேன்.
Yeah, today we are going to discuss about the very important topic, EB2 NIW, because nowadays the I-140 process is taking more time. So many people are asking about what is EB2 NIW. So can you explain that?
The EB2 NIW or National Interest Waiver is an exception or a special category under the EB2 where somebody does not need to have the employer sponsorship, but they can apply on their own. And the general idea is that the NIW is you telling the US government, give me a green card so that I can do X. And this X is something that's very beneficial for the United States. That's where the words national interest comes in. So in order to get an NIW approval, you have to have some kind of a future plan. The legal term for it, if you're reading about the NIW, is called proposed endeavor. That basically means what is your plan in the United States in the future, professionally speaking? And then the second question is, why is this good for the United States? So, for example, if somebody is working as a cancer researcher and they are building machine learning algorithms to help diagnose cancer faster, for example, then the argument is, my plan is to develop machine learning algorithms for cancer diagnostics, and this is beneficial for the United States because it will help us catch cancer faster, and then we will save a lot of people. So it's a public health benefit, right? Or if somebody is working in data center design, then the argument is I'm planning to design, innovative new data centers, and this is important because the US is in the AI race against China, and we try to build as many data centers for AI as possible. That's why there is a sort of strategic interest of the United States that is at stake here. So there's a lot of different arguments depending on exactly what is your profession or what kind of work you are doing. And the main point is you have to have some good arguments for how does the United States benefit from your work. And if they agree, then they will approve the I-140. So you just go straight to filing the I-140. You don't do DOL. You don't have to have the employer file anything. You just have to file the I-140 with the evidence and those arguments. And if the USCIS officer agrees that your future plan is something that's really beneficial, then they can approve the case.
So you have given some example, like you have said about the researcher or some analytics people. I can understand that. If someone working on the software developer and if they are working under some AI projects or something related with the AI, whether they will eligible for the EB2 NIW as well?
Unfortunately, not everybody who works on something AI related is going to have a good case. Few years ago, a lot of people in the big tech companies like Apple, Amazon, Meta, they were getting approvals for NIW if they could connect their work to some kind of bigger project at those companies. But nowadays, the approval rates for NIWs have been going down, and USCIS is really asking, they want to see, number one, that the work you are doing has larger scale, and that it goes beyond one company. So even if the company is really big, they still basically send an RFE and say, you didn't show us how your work benefits the field or the industry. You're just showing us how your work is benefiting Apple or your work is benefiting Amazon. But how does it impact, more than just one company? For that, when you are a software developer, it's really good if you can show, for example, open source work. Because if you can show, hey, I'm doing stuff that goes to open source, then you can say there's a lot of companies that are benefiting from my work, not just one employer. But if you are doing something that's inside one company and they are not sharing that information with anybody outside the business, then that makes the case a lot more difficult. I'll give you one example that I worked on last year that got approved. It is for somebody working in embedded programming, right? So they are kind of writing code for hardware systems and SoC chips and different stuff like that. And they have lots of contributions to the Linux kernel, to Android, to U-boot, bootloader, these kind of open source systems where a lot of different people are collaborating online and contributing the code and the patches and upgrades and improvements and things like that. So the evidence that we used in the NIW petition was their detailed plan for the future, and then also proof from, for example, the Linux kernel, from some of the code repositories showing that this person was a maintainer of some of those kernels, right? That some of the repositories, they were actually the decider who gets to look at other people's code and decide if the code goes in or it doesn't, things like that. So if you are a software developer, any kind of public or external stuff, open source, your own projects, hobby, things like that, can be helpful for the NIW. The question is just how much do you have and how impressive it is, right? Because the more, the better. Whereas if you just maybe post something on GitHub and put it there for everybody, but nobody reads it, nobody cites to it, and nobody's using it, then it's probably not going to help the case that much.
It makes sense, Henry. So how long does it take to process, Henry, if someone is eligible for NIW, so as per we have discussed, so how long does it process and get the I-140 approval?
Starting from just writing the application itself, usually it's about 2 months for us to put something like this together. If you're working on it on your own, you might do it a little bit faster, or sometimes it takes longer depending on how much evidence do you still need to collect from somewhere. But the package looks similar to EB1A in the sense that you usually want to have some recommendation letters and your certificates and degrees and different documentation like that. And then once you file the case with USCIS, you have two options. You can do the regular processing, and that one is really slow right now for NIWs. It can take even 2 years before they make a decision on it. But you can also use premium processing, and if you pay for premium processing, USCIS must reply within 45 business days. So it's not 15 business days like EB1A, it's 45. And if you look at the calendar and you exclude weekends and holidays, 45 business days basically means like more than 2 months, right? But it's still a lot faster than the normal processing of 2 years.
That is really great news, Henry, because if someone is on the 4th year, so they don't have much time, so they have only 2 years. So 45 days is really a game changer. As an applicant, how do I know whether I'm eligible for the EB2 NIW or not? Do they have any portal, or do I need to check with attorney? What are the ways?
In general, I would say that if you are working in a STEM field and you are doing something that you think has broad scale impact or benefit, that many people or even the entirety of the industry or economy is going to get some good benefits from your work, then it's a positive sign that you might have a good case for an NIW. But of course, my recommendation would be that if you are interested in the NIW, then just get a consultation with Manifest and we can look into it in more detail, because the legal requirements for NIW are very vague. It's like, okay, are you doing something that's in the national interest, and are you well positioned, meaning are you well qualified to do this thing? But unless you've done a lot of these cases, you don't actually know where the line is or how to know if you're going to have a strong case or not. And for that, the best way to do it is just to talk to an attorney, because I can have you fill out a questionnaire and tell me a little bit about what you do for work. But the best way for me to assess the actual strength of somebody's petition is to really talk to them and try to understand what they do for a living and how exactly do they do it. And, there's little details here and there that sometimes can make a huge difference on whether this is going to be a strong case or a weak case.
Thanks, Andy. Yeah, I just strongly recommend to check with the Manifest Law because it's a free consultation. You have the QR code on your screen. Just use the QR code and schedule an appointment. It's totally free. I want to understand. So this is just like a I-140 process only, right? It didn't give any advantages on the visa bulletin. It remains same as like the regular EB2, right?
Correct. If you already have, let's say, an EB2 or an EB3 from an employer from the past, then you really might not get much of a benefit from doing an EB2 NIW because you would be in the same EB2 wait list, and that means that you're not speeding things up. The main reasons for doing an NIW, number one, if you don't have an I-140 approved yet, then doing an EB2 NIW can be a faster way to lock in the priority date, because instead of doing the prevailing wage and then the labor certification and then an I-140, you can go straight to the I-140, file it, and the date that USCIS receives the I-140 becomes your priority date. So if you have a good case for an NIW, you can get a new priority date quicker, and that can help you with getting an exception for the 6-year limit on H-1B, getting your H-4 spouse eligible for an EAD card, like different things like that. There is a second category that is increasingly common now, which I'm very surprised by, but it's Indians who have a EB2 from an old company, and now their priority date is even current, but that company no longer exists, or the company no longer wants to sponsor them. If your priority date becomes current, then you are no longer eligible for H-1B extensions. So I just had that come up yesterday with somebody that they filed an H-1B extension and it got denied because they have a 2012 EB2 approval, even though that company is no longer sponsoring them anymore. They're already working for a totally different company on H-1B. But that's because, if you remember the rule, the H-1B extensions are only for people who have a priority date that is not current. So once your priority date is current, you have to apply for a green card. You can't keep just renewing your H-1B forever. But what if you can't apply for the green card because it's on an EB2 that requires sponsorship and that company isn't actually willing to sponsor you anymore? So in that situation, an NIW might help you because you can use that 2012 priority date, file an NIW, and then do an adjustment of status without an employer sponsorship, right? So those are the sort of opportunities that some people might benefit from.
That's a good point. So if you are not having the I-140 with your current company and you are expecting your date to be moved soon, so please check with the Manifest Law and just work it out how the EB2 NIW can help you to get the I-485 and the green card process quickly. Yeah, thanks, Henry. So how much the premium processing fee, Henry, for that EB2 NIW?
The same amount, the 2,805, just like for EB1A or for H1Bs. Your followers probably already know this, but just in case somebody hasn't heard, the premium processing fee with USCIS is going to increase on March 1st. So right now for EB2 NIW and for EB1A, it is 2,805, and starting in March, it's going to be 2,965. So for example, if you currently have a pending EB2 NIW or a pending EB1A, and you are thinking about switching to premium processing, I would recommend doing it now before it increases. They have this rule in the law that USCIS can keep increasing the premium processing fee just to account for inflation. So every year or two, you can expect that fee is going to keep going up.
You brought the good point about the H-1B extension cannot be processed after the I-140 date become current. Yeah, a lot of information we learned from you, Henry. Thank you so much for your time, Henry.
My pleasure. Always good to see you.
Nandri.
Nandri.